All right. Oh gosh, wow. I have learned as a professor to speak without microphone, so it's a bit of I've got to modulate. I've got to moderate myself, and I've got to moderate this panel.
Got these cool chairs.
Great. Yeah, good. It's always good to pivot on issues and have a chair in which you can pivot. So it is my honor to be able to moderate this conversation about an inspirational book by an inspiring author about an inspiring subject and leader and hero. So let me first introduce Professor Robert Tsai, my good friend. He's a professor of law here at BU. This is his fourth book. So his other books are Eloquence and Reason, Creating a First Amendment Culture, America's Forgotten Constitutions, Defiant Visions of Power and Community, and Practical Equality, Forging Justice in a Divided Nation. I think those titles, if you do the New York Times crossword, there's often a series of clues. And if I had to think about Eloquence and Reason and America's Forgotten Constitutions and Practical Equality, I would think about Robert Tsai's books, and I would think about Steve Bright's commitment to equality in practice. So there's a lot I could say about Steve Bright. He is Harvey Karp Visiting Professor in law at Yale Law School. He's tried numerous capital cases and even won a bunch. And he served as director of the Southern Center for Human Rights in Atlanta. And he's the author with a former student, James Kwok, The Fear of Too Much Justice, Race, Poverty, and the Persistence of Inequality. He received the ABA's Thurgood Marshall Award in 1998. He received an award of Agitator and Newsmaker of the Year in 2003. And Lawyer of the Year in 2017 for success in challenging racial discrimination. And if you'll give me the privilege to read one more thing, this is from the acknowledgments of my book from a few years ago. In the acknowledgments, I say in the beginning of these acknowledgments, I thank Steve Bright for being an outstanding teacher and being the first to bring this issue of judicial elections to my attention back when I was a 1L, and I was one of 3 1Ls to get into a class on capital punishment. I'll say more about that in a second. Steve introduced me to Penny White, a former Tennessee Supreme Court justice. There's a reason why she was former. She told her story about how she became a justice and then a former justice because of a single death penalty decision. They motivated me, Steve and Penny, to investigate this topic, and from my perspective, was driven by moral outrage. And that was the beginning of the project, to think about the many different ways that a democracy over justice has been a problem. But I will just acknowledge that, and in these acknowledgments, I just have, as I said to my class just before now, I didn't learn that much civil procedure in my Civ Pro class. I really learned Civ Pro in a capital punishment class that you taught so amazingly with tremendous, given the nature of the class, you taught it with a degree of balance, but also challenging us to see what the arguments were from the other side. And it was really your ability to navigate those different arguments that one would have to make, because you had to make those arguments. You knew what judges would expect and what skeptical judges. And so you really were an outstanding teacher from that practical background. And so thank you for teaching me Civ Pro among many other things, Steve.
Thank you.
Great.
Great to be here.
Great. Well, why don't maybe I can just give you the floor for a couple of minutes, just for Robert, you to talk about the book and how you decided to write it, how you came to the subject, came to Steve, and then what you hope to communicate to this audience. And then we'll turn to Steve to talk about what it's like to be the subject in this book. Great.
Well, first of all, the first time I asked Steve Bright whether I could write about him, he told me no. And so I moved on to other things, and those other things were my last book, Practical Equality. But luckily, he had a gander at that last book, and I guess saw something in there that caused him to change his mind or rethink it. And so he sent me an email saying, well, I have some mild regret about saying no to you. And I said, well, I'm between projects right now, so if you're really serious about this, maybe we can get started right now. And one thing led to another, and then the book was produced. But I was really excited, and really this was a project of joy among the various things I've been a part of to be able to do, because I had long heard stories about Steve Bright's escapades in court as well as outside of the court. And I was also hoping to write a book, finally, that could be a more inspiring kind of story in this age when so many of us want to do something to change the world, but feel at a loss at times in terms of what can be accomplished. I saw in Steve Bright's legal career the work of the Southern Center as an organization, particularly in those early decades of mass incarceration, the improvements that could be accomplished if people sort of stayed at it with their sort of nose to the grindstone. And so, I'll leave it to others to see whether we're able to accomplish this. But when I interviewed Steve over the several interviews we had and people who worked with him and so forth, that was really the one set of goals I had, was to be able to tell a story, a true story, about one lawyer and one organization that had some allies, of course, but were able to do a tremendous amount during a period where the political climate was quite hostile to notions of equality and justice.
Well, great. Yeah, Steve.
Well, as I say, I'm glad Professor Tsai decided to write a book about us. He wrote about the cases we won. I tell you, there were a lot of others that didn't come out nearly so well. And I think I should say a little something that about 9 months before this book came out, as Jed said, my former student of mine, my good friend now, James Kwok, and I published this book called The Fear of Too Much Justice, which is basically stories of everything that we saw at the Southern Center for Human Rights in the 30-some-odd years that I was there, and how they sort of played out. So I think the books sort of complement each other. Because we wrote our book from the standpoint of telling people, not lawyers, not law students, but telling people in general what the courts are like in terms of prosecution, how much power they have, counsel, how much problems we have with the right to counsel in so many places, discrimination in everything from policing to charging to striking juries to sentencing. All of those kinds of things, and of course those are the same issues that we dealt with in the cases that the Professor Tsai writes about in the book. 3 of the cases are about race discrimination in jury selection. One is about a poor person accused for crime in Alabama, whose lawyers have no earthly idea what they're doing, not unusual in Alabama. In particular, they had a lot of records about the mental health of this client, but they had no ability to understand that. And so they asked the court to give them an expert to just explain things to them, and the court denied it, but the Supreme Court said they were entitled to it. So I think a lot of different issues there in terms of problems that we have in the criminal legal system, and some efforts we made to change it and improve it. You're subject to the book.
Yeah, building on what you both were just talking about in framing this book, I wonder if you could talk first, Robert, how you picked the 4 cases that are the structure of this book. How you picked? Can you talk a little bit more about each of those? Talk about those 4 cases and how you chose them among the many choices you had from Steve's career. And then maybe Steve, after you hear that, then talk about what it was like to read about those cases in this book and any reflections you have about that narrative. Yeah.
Sure. In terms of the choices, the writing choices I made, this was really through a process of negotiation with my editor and the book that we sort of envisioned over a series of conversations. I initially wanted to write this gigantic book, and they're like, well, we can't really sell a gigantic book. But we settled on a framework where we could focus on the 4 cases that Professor Bright argued in the Supreme Court of the United States. And then I was able to then intersperse, within that framework, other kinds of things. For example, Professor Bright's and the Southern Center's advocacy to improve the indigent defense system in the state of Georgia. So I go into this a little bit in the book, but there's a moment in time where a lot of the flaws in the criminal justice system that they've been showcasing over the years through their individual cases seems to be percolating into the political climate, and there are some people interested in making a final push towards creating a kind of a framework legislation that would establish for the first time a statewide public defender. And so I get into this a little bit, but that's also to illustrate that there can be a kind of connection between in-court advocacy, especially if you're a cause lawyer, you work for an organization like this, and the out-of-court stuff. And increasingly, I think this is the direction that the Southern Center also goes. So if there's an arc in the book, there's these 4 cases, but it's at the beginning, Steve Bright, after he's trained as a public defender in D.C., is called down to the Deep South to take over this organization started by ministers and help prisoners, especially those who are on death row. At first, these are sort of individualized kinds of cases and highly focused on trying to get stays of execution and so forth. And of course, Professor Bright loses his first 2 clients in those early years. But eventually, they settle on a series of arguments that start to, I think, erode what seems to be pretty broad support for capital punishment across the political spectrum among Democrats as well as Republicans. But these individual cases start to showcase problems, like the ones that Professor Bright just pointed out. And then there's this moment later on, and so this is part of the arc of the book, where political reform is something that becomes possible because of all the incremental work that had done in these individual cases. But just very briefly, the 4 cases. The first Supreme Court case that Professor Bright argues is in '88 on behalf of a man named Tony Amadeo. And I won't spoil all of the legal drama that's involved in that case and the twists and turns. And there are many, including Professor Bright getting thrown off the case by a judge who was hostile to having Tony Amadeo have a decent lawyer. But that case featured whether a piece of smoking gun evidence would be allowed in his case and be looked at on the merits. The piece of evidence was a memo written by a district attorney instructing jury commissioners how they could underrepresent women and black people on juries if they so wanted. Of course, they complied and did that. And so, there are all these twists and turns in Professor Bright's advocacy to try to get courts to take this seriously. They're battling the 11th Circuit, though they have a friendly district court judge. And eventually this case goes to the United States Supreme Court. And of course, Tony Amadeo, who's been on death row since the age of 18, finally has the shot in the U.S. Supreme Court. And I try to dramatize that aspect of the story, going back into the transcript and recovering the really fascinating exchanges you had with Justice Scalia, who had just joined the court, for example, and others who might be skeptical of his claim. The next 2 cases involve peremptory challenges. This is this Snyder case, as well as Foster versus Chapman. We can go into that a little bit more if you're interested, but those involve the specific discretionary decisions by prosecutors to eliminate people from the jury pool, which are traditionally ones that you don't have to give a reason for. But in a case called Batson versus Kentucky, the court finally ruled that equal protection of the law is violated if a single juror is removed because of his or her race. And the problem, of course, is that this is incredibly difficult to make out Batson claims. Judges are quite skeptical. And there's also a question of how tolerant judges are during the chaotic process of jury selections. So those next 2 cases showcase, I think, the special challenges that come up in these kinds of cases, especially when the stakes are so high. So many of these death penalty cases involve, for example, African-American defendant and a white victim. And in those cases, you have the greatest pressure on these prosecutors to try to manufacture all-white juries. And this is true even in the 80s and 90s, we see. And so I think we have some continuing issues there. Then the final case I won't go into because Professor Bright just talked about, but those are the 4.
Yeah, great. And so, Steve, what was it, as the subject and reading how those 4 cases unfolded, what's your reaction to how that was reflected back to you and your experience of those cases?
Well, I think those cases, they're good stories with regard to those cases and important stories, not just how the case was litigated and how it was decided, The book that James and I wrote was not at all autobiographical. We wrote it sort of looking objectively at the system. And I think what Professor Tsai does is describe a really pretty remarkable story. Here's a prosecutor, district attorney, who writes to the jury commissioners and says, underrepresent black people by 10% in the jury pool, which is, obviously patently illegal. It's jury rigging on the basis of race. And yet when that came to light, the courts in Georgia weren't troubled one iota by it. And even when a federal district judge said, this is outrageous, this is race discrimination, the real issue, there's no question it was race discrimination. The issue was the Georgia court said, well, you should have raised it before trial. Well, of course, he didn't know it before trial. This was found several years after trial. And the real question was, could the courts consider this, as Professor Tsai said, smoking gun evidence of race discrimination? A federal district judge said yes. The 11th Circuit remarkably said no. And Tony Amadeo was about to be executed. And we sort of threw this Hail Mary pass at the Supreme Court. Lo and behold, granted the case. And fortunately, when you really told the whole story to the court, we got a unanimous opinion written by Thurgood Marshall saying this had to be considered. But there was a lot to that case and these others. The two other race jury cases were cases involving fairly outrageous racial discrimination in jury selection, particularly the last one, Foster. Tim Foster's case was a case in Rome, Georgia, where we found the records we were able to get through the Open Records Act many, many years after the trial, the records, the prosecution's file with regard to jury selection, which told us that there was only one thing they were concerned about: keeping black people off the jury. There's a memorandum in there that says if it comes down to having to take a black person, Ms. Garrett might be okay. But Ms. Garrett was never in the running to be on that jury. When we got the file, we found out that not only were there things like that in it, which made it clear that the whole purpose of the jury selection was race discrimination, but that the prosecutors lied with regard to reasons. I'll just give you one example. Eddie Hood, one of the black people who was struck, and the prosecutor said, we struck Eddie Hood because he was a member of the Church of Christ. And the Church of Christ was so adamantly against the death penalty that we were told, don't ever let a person from the Church of Christ be on a jury. Well, right there in the file, in the prosecutor's handwriting, says Church of Christ takes no position on the death penalty, leaves it up to each individual member. So the prosecutor intentionally misrepresented what he knew to be the facts. And so when that case got to the Supreme Court, the only justice who voted to uphold it was Clarence Thomas. Everybody else agreed that this was intentional race discrimination. But it also shows you how serendipitous these things are, because if they had destroyed those notes, if they had shredded them or burned them or whatever they would have done, which I'm sure they would have if they had thought we would ever get hold of them, Tim Foster would have been executed. And again, when these very dramatic facts came out, it didn't bother the courts of Georgia at all. They reaffirmed the death sentence, rejected his claim, both the trial court judge and the Georgia Supreme Court, not even a dissent at the Georgia Supreme Court, and yet the United States Supreme Court reverses the case once they look at the same evidence.
So one way I read this book is in the context of, I was reminded of some social science evidence about how to change people's minds, right? There are, and there's some question about how strong the social science is, but on the topic of abortion, for example, and this might be a campaign issue at some point, but when one way to change people's minds is to go door to door and actually have a conversation with a human being, and that takes an abstract issue about which people have very abstract and maybe very intuitive notions, and humanizing it and telling a story about it can change someone's mind. So this is a biography in some ways, but there are biographies nestled in it. So two ways I'm thinking about as a reader of this book, and I just would invite you to as an author, think about how that was a part of your writing process. A biography, both of the lawyers, Steve, and the story you tell is not just about Steve, lone lawyer working by himself, but a team. This, for example, the smoking gun. Steve didn't find the smoking gun. Right. He hired a smart lawyer, was working with smart lawyers who found the smoking gun in Amadeo. And so it's a biography of lawyers who take on this difficult, thankless, day-to-day work. It humanizes them, but it's also in some ways a biography of the defendants too, right?
Yeah.
So and given, I wonder how much that was part of your writing process to humanize these lawyers as role models to our students and to many other lawyers out in the world, and also how much you were thinking about humanizing the defendants as along the way as part of as mini biographies as part of the story.
This is a great set of questions. I guess the way I would answer your questions here is to note the following. I did want to humanize the protagonists, including Steve Bright. I think that they've been doing thankless work for many decades. I also think that something happened with the civil rights movement when it went mainstream. So, and this includes the NAACP's work, and so I try to remind people in the book that the NAACP itself starts in the wake of, is founded in the wake of race riots, where they were worried about a black person being lynched, not getting equal justice. And a lot of the early cases the NAACP is involved in are the kinds of cases that the Southern Center end up taking up in the 70s and beyond. And so, once the civil rights movement goes mainstream and focuses on schools and workplaces and so forth, it's not that the criminal justice piece falls totally out of the picture, but it has fallen out of our political consciousness. And it's true that part of the reason why is that the advocacy ends up primarily, and the resources moves in this other direction. So I wanted to showcase that Professor Bright and others who do this work have always seen themselves as working in that same civil rights tradition. And as I describe it, doing the leftover work of the civil rights movement in the places that the movement bypassed. So in Southern courtrooms, in Southern jails, and in Southern prisons. So that's I think one thing I really tried to do is to show that they saw themselves this way. And if that humanized them in the process, that's great. The other way I would answer your question is that I have long thought in my work that while universal moral arguments are important, they only take us so far. They take the most committed quite a long ways. But there are people who are not so ideologically committed, and in order to reach those people on the things that matter the most, you're absolutely right. You've got to find ways to empiricize the problem. And that might mean to zoom into one person's plight or a series of people's struggles, and then to zoom back out and show that those struggles are not theirs alone. They're reflective of some broader practice. I think the Southern Center was quite good at doing precisely that.
Yeah. What do you think, Steve? As the human in the story, working with the other humans.
But
yes.
the other people are really important. We talked about Tony Amadeo's case. Tony, after winning his case in the Supreme Court, he served 38 years in prison. He was paroled. I went to see him not too long ago. He now runs a ranch in Texas. We've been in touch a lot in the last couple of weeks because he just had a kidney transplant. He was on dialysis for 15 years, and he's doing very well and recovering from that. But here's somebody that, when he was 18 years old, this crime took place in Georgia, and 2 months to the day later, his trial started. There were 3 young men involved in this robbery murder in Georgia. Tony's trial started on Monday, he got the death penalty on Tuesday. The other fellow started on Wednesday, he got the death penalty on Thursday, and the last guy who testified against him pled out on Friday. So in 1 week, they tried 3 death penalty cases. And again, nobody knew at the time they were trying these cases that the prosecutor had told the jury commissioners to underrepresent black people on the juries. In some ways, it was serendipitous that turned out to be the case and that we got the case reversed because of that. But there are a lot of stories with regard to that case. And one is about the fact that, when he's 18 years old, the legal machinery in Georgia says he's so beyond redemption, he should be eliminated from the human community. And yet here today, he's a useful and productive member of society who's living his life out in Texas and doing very well. And there are other people in there as well. Jimmy Horton's case is described, and when I met Jimmy Horton, he was on death row. It didn't look very good for him legally, but we won't go into all the details. Let's just say ultimately his case was set aside by the 11th Circuit. Again, this was back when the federal courts were playing a much greater role than they do today in looking at these cases. And again, he's been out now for a number of years and living his life. So, I think a lot of people have a sense of the death penalty as being just the most incorrigible people that committed the most terrible cases. Actually, it's not that at all. In our book, in the book James and I wrote, we talk about a couple of women facing the death penalty in Georgia. Both of them involved in the crime that they were involved in with another person, the boyfriend in one case, the husband in the other. And the prosecutor gives them all the same choice. Plead guilty and you'll get life. Testify against the other. And the men sign up, yeah, sign me up. I'll testify. Love is over. I'll testify against them to avoid the death penalty. Both women don't, and then go to trial. And in Tiffany Moss's trial, the second case, the prosecutor says in closing argument, there's some crimes that are just so horrible that the only appropriate punishment is the death penalty. But of course, he knew better because he had offered her life in prison. He was willing to give her life in prison as long as she would plead guilty. The only reason she got the death penalty was because she didn't take the plea. I'm not sure a lot of people understand that. And that both of these women, Kelly Gissendetter was executed a few years ago, and Tiffany is now on death row as a result of that. That many of the people who are on death row or serving the longest sentences today are there because they didn't take the plea offer. And this is a tremendous power that we give prosecutors to threaten people with that kind of result if they don't take the plea in these cases. Tiffany Moss is a terribly tragic case. She was a brain-damaged woman. She wouldn't take a lawyer. She just sat at counsel table during the trial. Didn't do anything. Wasn't involved in jury selection. Didn't give an opening, closing. Didn't question any witnesses. It was just the prosecutors trying the case like they're trying the case of the century, and then this black woman sitting at counsel table not doing anything, just sitting there with her hands folded and waiting for the jury to convict her and sentence her to death.
So,
Can I just jump in here?
please.
Yeah,
Yeah.
let me just build on something Professor Bright said about the Horton case. So the Horton case is one that I became fascinated with during the writing process for a couple of reasons. One, it wasn't one of the four major cases that went all the way up to the Supreme Court, so it hadn't got that kind of attention, that broad attention. The second reason why I was fascinated with the Horton case was because I thought that perhaps even more so than a lot of the other cases, it showcased your skillfulness, your resourcefulness, your creativity, that of interns at the Southern Center, lawyers that were on staff. The Horton case was one where we had the same prosecutor, right? Joe Briley,
Right.
who was the one who put Tony Amadeo on death row. And he was also someone who bragged that he had put more people on death row than anybody else in the state of Georgia, some 30 plus people.
And he had about 40 people.
About 40
people. And they called him Death Row Joe.
Death Row Joe. And so we had Joe Briley again in this case, another all-white jury that he manufactured with the African-American male on trial. And but in that case, you and your staff were able to go back and look at all of the cases that he had throughout his entire career as a prosecutor, and then somehow look at all of the jury selection decisions he made. This took many, many months. And then you gave that evidence to a statistician who ran the numbers, and then you drawing on a case that was a terrible case, so any law students in the room will know this case, McCluskey versus Kemp, and you said that McCluskey is not totally terrible. It's something we could use as a sword. You asked a federal district court judge to give you a hearing so that you could, for the first time, introduce this evidence, and you got it in the record. And the next thing you know, the 11th Circuit, you get a win. So to me, this was one of the more remarkable things, and I fought tooth and nail to make sure this case stayed in the book. But I wonder if you had any additional reflections about all of that work all through those summer months, I think it was.
Yeah, and as Professor Shugerman said before, this book is a whole lot of people, and you both said, I just happened to be the guy that was there along with everybody else. I mean, that case, we had to prove that the prosecutor in case after case, no matter who the defendant, no matter who the victim, no matter what the issue, that he used his jury strikes to keep blacks off juries. And it was supposed to be impossible. It said you can't really prove it. Well, actually, we did. But it was incredibly time-consuming. As Professor Tsai said, there were 8 counties in that judicial circuit, and we had to go to every courthouse and go through every trial that Joe Briley had ever done, and then we had to get the statistics on how he'd used his strikes. Nobody kept these statistics. We had to do it case by case, trial by trial, and then, as you said, give them to a statistician and show that the likelihood of this happening at random was 1 in a zillion. Basically, every opportunity he had to strike a black person in jury selection, he struck them. And even when we were doing it, I didn't think we'd ever win. I thought we were telling a story that would give a certain backdrop to the case about Joe Briley. I mean, this is after he had already been slapped down by the Supreme Court in Tony's case, so of course, that was a big part of our argument. This guy's a real racist. He rigged the jury. He used all these strikes. He did all this. But lo and behold, the appellate court saw it our way and held that he had discriminated in all the cases, including Jimmy Horton's case, and got that case set aside as a result of that. But that was the case of the paralegals at the office, the other lawyers, and we also had a law firm that was helping us on the case as well, and everybody, all hands on deck. It was a great group effort that resulted in that case coming out the way it did.
So Steve and Robert were generous enough to come to my seminar right before this, so the Historical Perspectives on the Law as a workshop. And one point that you made about Amadeo, which leads me to ask a question to both of you. You said that if Amadeo's appeals had happened after 1995, that he'd be dead, because the Clinton administration signed on after the Gingrich Revolution to the Anti-Terrorism and Effective Death Penalty Act, AEDPA, of 1995, and how much a statute and how much what's apparently boring procedure is a life and death matter, that Amadeo would be dead if the appeals had happened at a different time with the same substantive law.
And Jimmy Horton would be too.
That's okay, good. I mean, not good, that's bad. But good that he's not, right? But the larger, several students asked a question we didn't quite get to in the workshop, maybe some of them are here, about this concept of legal liberalism. The other biography, just like Akhil Amar writes the constitutional biography, there's a biography of legal liberalism that, Robert, you're writing about here in a heroic way about Steve. And some students pushed back. So just the legal liberalism framework that you're celebrating is a lawyer's case-by-case procedural fighting for the enforcement of the Bill of Rights and the 14th Amendment against democracy's excesses, to use the Constitution and use the law as a limit on democracy. That's one way what's one way that you approach legal liberalism. Several students asked, given your background, Steve, of what was happening in the 1960s, and in fact, I just taught in Fed courts this week a case related to the Kent State shooting that was, that you described in the biography, that Robert describes as this pivotal moment, about the students were asking about whether legal liberalism is worth celebrating as much at a time where it seems like radical change is the only way to handle this much injustice. So I wonder if you might take this opportunity to address the students that are saying, let's not be, legal liberalism is dead. in the 21st century. We need radical, we need legal radicalism, not legal liberalism. I wonder what you might say about whether that choice to frame that as another biography or another hero of the story. And Steve, what your thoughts are about those different ways of framing justice.
I'll go first. I try. I mean, I'm in the book, but I tried to keep my own theoretical perspectives, in the back of the story. I do use that phrase, legal liberalism, in the book because I do think that insofar as Professor Bright sees himself as a cause lawyer working within the civil rights tradition and the Southern Center as well, that reflects an approach to legal change that is often court-centered. And many kinds of problems are described as problems of individual rights, and that's the way to sort of approach things. I would say much of my work is not necessarily in that tradition, although I once was a cause lawyer myself, going way back when. I don't describe myself in exactly those terms.
Right, just a pause there. This book is, your other books I would not describe as, I mean, I don't think they're opposed to legal liberalism, but they're all three of your other books are written at either a broader, broader reformist, and they're often challenges to legal liberalism. So just to pause on, so I'm just putting this last book in conversation with your other books. This is more sympathetic to legal liberalism and that kind of practical lawyering, as opposed to the broader vision of practical equality.
I did think that the choice I made was to put this approach, which I described as legal liberalism, in the best possible light. And in that light, I think that there's an incredible amount that one can do to reduce individual suffering, particularly when the stakes are so high. Someone's under death sentence and so forth. And they were also very, very good at showcasing the various structural problems in the criminal justice system. So all that, I think, can be attributed to legal liberalism. But I also found these places where I suggest that they couldn't stay in that place of just helping individual clients. They were showcasing structural problems that really had to be better addressed by others, elected officials. The Southern Center itself has become much more grassroots as an organization. They built out its lobbying component, particularly during the indigent defense fight. And I think ultimately that's where my own inclinations are anyway. So even though the book is framed that way, I do have that in there. I just didn't want to be heavy-handed about criticizing the approach that I think that this reflects.
So, Steve, what would you say to the students who were pushing you to be more of a legal radical or asking about that approach?
Well, I was going to say, regarding your initial question there, it might be that I would be for the radical solution, of course, assuming what it is and what the issue is. The issue really is, though, is it ever going to happen? And, a lot of people can say, well, we ought to have A, B, C, or D. I take my clients as I find them, with the cases I find them, with the courts as I find them. And unfortunately, that's the reality of life. And I would like for it to be a whole lot different. But the reality of it is that, what happens or not is very much a matter of really incremental things. If Al Gore won the election, or did win the election, if the Supreme Court hadn't taken it away from him, and Gore had appointed lawyers to the 11th Circuit, people that died would be alive because there would be different judges on the court. So that's not a radical change, but that's a change in individual cases. My clients, it makes a huge difference whether they live or die. Depends upon Democratic judges are more likely to rule in their favor, and Republican judges almost always are going to rule against them. That's just the facts of life. And so here we are now with the courts in really bad shape after the Trump administration, and the Supreme Court in particular in bad shape. But one of the things I always say is you have to look at what's going on in the states, and we are getting some solutions to some problems in states that we're never going to get, at least from this Supreme Court or from the Congress, whatever. And what really, I tell my students, what's really important, not so much 9 people on the Supreme Court as 12 people on the local jury, and the local DA, and the local judge, and the local people, and whatever, because most cases are not Supreme Court cases. It's one, I argued Amadeo, I didn't have any more Supreme Court cases for years, never expected to ever have one again. But, lo and behold, all of a sudden these cases came along. So there we have it.
Great. I love to open things up to see if there are questions. Just as I do, I just want to make one observation about the partisan ways of these issues are shifting on elections. It also turns out 2016 was a decisive election on this, right? Yeah. Obviously, but it is worth noting that going into that 2016 election, when Obama could put someone on the court, he nominated not someone who was likely to be a death penalty abolitionist, and not even someone that was likely to be a death penalty anti-death penalty incrementalist. Merrick Garland, the Scalia seat would have been a turning point seat on the death penalty, and Merrick Garland was not the kind of nominee who would have moved things in a positive direction. Whereas Souter and Stevens, Republican appointees, just recently on the court, would have been far to Merrick Garland's left on death penalty questions. So it is just worth noting that maybe this is also an argument for both and, right? Legal liberalism plus pushing in politics
also
to demand
that everybody has to be aware of the political realities. Obama saw that he wasn't going to get anybody on the court like that. He thought maybe if he put Merrick Garland on, of course he thought Mitch McConnell was more of a statesman than he was. But there was a strategic part of that I think people have to deal with that, and even that didn't work.
So
nobody more to the left of Garland would have gotten affirmed.
But this isn't hindsight. Even at the time, and maybe even I said this, is that if Obama had nominated a more left-wing candidate, knowing that Mitch McConnell was never going to put anyone on the court, then to have maybe a person of color, a woman, a more left-wing nominee might have actually mobilized some more voters to see those stakes. It's impossible to know, but that was an argument that was out there at the time.
Well, it's true. Nobody's going to take the streets from Merrick Garland.
Right. Yes, and his attorney generalship has been fantastic. No sarcasm there. Let me invite people to jump in. Yes, please. What's your name?
My name is Amy.
Do you want to use the microphone too? Because then it'll get recorded. Thank you.
Testing. Nope. Let's go.
Is it on?
I think we can hear you.
We can just.
Okay. Help is on the way.
Okay. There we go. Thank you. First of all, the stories in the book, it's one after the other, right? And it's so horrible, so extreme of incredible, malfeasance by many players, right, in the criminal justice system, only by chance to be overturned by the U.S. Supreme Court. And the title is so brilliant, right? The fear of too much justice.
Oh, I didn't know which book you were talking about.
They're
Thank
both, both books look fantastic. I just bought them.
It's a both and comment. Both books are fantastic.
Both books. But the title, and in both of these books, it's one thing after the next, right? One horror story after the next. But the fear of that's really a why issue, right? The fear of too much. Now, what is the fear of too much justice? Like, what is it about us in America that, it's like post-George Floyd, everybody is, doing everything they can to be on the right side of history. And then now, the tables have turned and now people are against bail reform and everything's. What is it about us? We can only handle a crumb of justice. We don't want everyone to have it, and it pervades everything, right? Like, what do you think it is after having been in this, Steve, right, for being in this business for so long? What is it about America that we can only handle, everyone just gets a little crumb?
Well, of course, the title of the book comes from the McCluskey case. It was a case that went to the Supreme Court that showed very clearly, with a very sophisticated multiple regression analysis, that If the case involved a white victim, it's much more likely to get the death penalty. If it involves a black defendant, it's more likely. And if you have the two together, it really ratchets it up and you're likely to get it. And the court had the opportunity there to do what it had done earlier in Furman versus Georgia, all these cases out of Georgia, to say that this kind of discrimination, this kind of arbitrariness was unacceptable. Justice Powell, in his majority opinion, writes that if we dealt with race discrimination in the death penalty, we would have to deal with race discrimination in all other kinds of sentencing. And that wasn't the first time he had said that. When Furman versus Georgia was decided and some of the justices in the majority had said there's race discrimination in the death penalty, Powell said exactly the same thing. And Justice Brennan, in his dissent, said this sounds like a fear of too much justice. But I think it not only explains the unwillingness to deal with race discrimination in sentencing, race discrimination in jury selection, which is rampant, but also with a lot of other issues. I think one of the issues we have with regard to right to counsel is that public defender offices are under-resourced. They don't even exist in many places. I mean, there are many, a lot of people don't know, there are many places in Alabama and Texas and Arkansas, and there are no public defenders. They just appoint any local lawyer who's a member of the bar and give them these criminal cases and pay them a pittance and process people through the system. And I think there's a real fear there that if we provided more resources, if we had better public defenders, more cases would go to trial, more people would be acquitted. And that's just more justice than I think a lot of people in the system want. I think they sort of like it the way it is. Judge Posner on the Seventh Circuit once wrote in one of his books and said, you know, I can tell you as a judge, I can tell you that most people that are represented by court-appointed lawyers, that those lawyers are not very good. But he said, if we're going to be hard-headed about it, that may not be such a bad thing, because we don't want to pay a lot of money for the lawyers, and they probably keep most innocent people from being convicted. Well, that's a pretty straight up, he didn't say this one night when he had too much to drink. This is in a book. He wrote this in a book and said, this justifies not spending any money on representation for poor people accused of crime. There are a lot of other reasons people don't want to spend money on that, but I think we try to point out that there are places where we are meeting a standard of justice, but we're not willing to go there most of the time, and we're not willing to go there in other places. And I think that is a fear of too much justice. And I think it's a failure on the part of the Supreme Court in particular, but lawyers in general, to sort of let's look at the best we can do here, as opposed to let's just get by as close enough for government work.
Your comment reminds me of, I can't remember where I saw this article, but I think its title was N Innocent Men. N is the stand-in for, so the comment is, better to have one guilty man go free than 100 innocent men get 10. But the problem is that number can always change based upon how much a society cares about justice. So that N is a stand-in, like one society might say, better to have one guilty man go free than one innocent man get convicted. That's a perfectly coherent way to think about justice. But that's not America. America, that N is large.
Well, and you know, this is a very interesting thing about innocent people. Right now in my class, we're working on 4 different cases involving innocent people sentenced to death. Now, you would hope the death penalty would be the last place where a lot of innocent people would be sentenced. But we're almost to 200 people who were sentenced to death have been exonerated.
Yeah.
That's remarkable. Now, when Judge Hand, the learned Hand, he was a great judge, a great man, but he said one time, don't worry about innocent people. He said, with the presumption of innocence, proof beyond a reasonable doubt, there are no innocent people being convicted. If you said that today, you'd be laughed out of town. I mean, to me, what's been remarkable is we have all these DNA exonerations, but now we have all these innocence projects all over the country proving over and over again that people, I just was looking at a case the other day, a guy 33 years in Texas, convicted in Dallas, you know, finally exonerated and coming out, not on DNA evidence, just on old-fashioned gumshoe investigation. This is a really damning indictment of our criminal justice system. We should not be convicting innocent people. And the fact that the courts are not even sorting it out, separating the guilty from the innocent, that's a fundamental failure of our courts, and we ought to be a lot more concerned about it than we are.
Great. Sorry, Robert, you were going to jump in?
Oh, I mean, the only thing I would add on as to the previous question is maybe even more than fear of too much justice, it's fear of too much social disorder. So the way I put it in the book is, there's something happening in the 70s and 80s where America starts to become the worldwide leader in the number of people we put behind bars, and then also top 5 in the world in executing people. And it doesn't happen overnight, but it clearly has to do with perceptions of social disorder more broadly. And then the question becomes, well, what is causing those perceptions to change? Because we weren't always like that, right? We didn't always incarcerate at that rate. We didn't always execute people at that rate. And that's a harder set of questions to answer. It's partly due to changes in media. You start to move to things like radio, shock radio. You start to see the rise of 24-hour news. That has a lot to do with it.
Right.
And others have talked about polarization of the parties and so forth. But there's a lot of things going on there that I think continue to keep this cycle. And although we've had movements now to try to chip away at the legacy of mass incarceration, we haven't changed those underlying numbers except for the capital punish part of it. The numbers of people being incarcerated has dropped just a little bit, but remains at a very, very high water mark. So.
Yeah, executions have also, the number of executions has dropped quite a bit.
That's right.
Oh yeah, and I would say this, the encouraging thing is that, when I started doing this work in 1979, 38 states had the death penalty. We were sentencing around 290 to 300 people to death every year. Now 27 states have the death penalty. 2 of those have nobody on death row, Oregon and Wyoming. And of the other 25, most of them haven't sentenced anybody to death in years and haven't carried out an execution in years. And now we've gone from 300 or 290, whatever it is, ever since 2000, it's been declining. Now we have somewhere around 30, 40 people sentenced to death every year. That's just a huge, huge change. And they're coming from just a few places. Only, about 7 or 8 states now sentence people to death every year, compared to what it used to be. So it's a huge change there.
Could legal liberalism be the hero of that story? Was it not just culture changed, but also the fact that so many lawyers were challenging the system case by case, that made some people give up on this isn't worth it.
The system, when I got in on it, was a system in which, like take Houston, Texas. Houston, when Johnny Holmes was the district attorney, they would sentence 11 or 12 people to death every year. This is one county. Harris County has executed more people than any state, 134 I think it is right now. That's more than any state except Texas itself. And the state in second place, Oklahoma, has executed 120. So this one county in Houston has executed over more than anybody else. And the way is very simple. Aggressive district attorney who sought the death penalty in every case, and judges who appointed totally incompetent lawyers to defend those cases, and gave people equally incompetent lawyers to handle their appeals. And let me tell you, if you do that, you can run a lot of people through the system very quickly. And that was going on not just in Texas, but in Georgia and all these other places. And what disrupted that was when good lawyers started coming in and taking those cases and investigating the facts and developing and raising claims and litigating those claims. And at some point, it became, it wasn't worth a candle. And now you don't have prosecutors like Johnny Holmes anymore. Anywhere, you don't have Joe Briley's anymore. But at that time, there were a lot of prosecutors that their whole identity was the death penalty. They sought it every opportunity they got it, there wasn't much trouble. Joe Briley's death penalty cases, I had a lot of them. A lot of those trials took place in a day or two. I mean, David Peake started trial, 9 o'clock in the morning, a presumption of innocence. 12:30 that night, just after midnight, he's been convicted and condemned to die. I mean, it's just that ridiculous and that perfunctory. And that has changed, and that change has greatly stopped the death machine.
So just to build on that,
Sure.
I think the only other thing that hasn't come up, which I would underscore, is one of the benefits of what's called the legal liberal approach, getting lawyers to represent people in a situation where there's deep asymmetry between the state and the individual facing these serious charges was one part of it. I think the part of it we haven't talked about is what we may call the educative component of the cause lawyering and how that can change how institutions can respond. I had the pleasure of interviewing two of the former justices of the Georgia Supreme Court, and they both confirmed that at the beginning of their time on the court, they were really not that knowledgeable about criminal law, kind of indifferent to these structural problems. But because of the cases being brought mostly by the Southern Center, but also others, over and over, they were so appalled. I call this process shaming the system. You're quite good at this. That the justices themselves become much more receptive to the claims of injustice that were being brought. And one of the justices, Norman Fletcher, who was just a country lawyer, I think mostly, right, had no criminal law experience really, or very, very minimal, before joining the court, says that after seeing all of these cases, he had a kind of Harry Blackman-like conversion. So he went from someone who thought that you could be a judge in these cases and kind of do justice to a position where he thought this is impossible. We'll never get to the point where these cases could truly be done in a fair and equitable way. So he announced that he was against the death penalty, I think, and he credits much of the work that was brought by the Southern Center.
Right.
Great. Other questions? Yeah, please. Do you want to go to the microphone? Yeah.
It'll get recorded.
Yeah, just for the.
So you were saying that obviously there is more reason to be hopeful about the state of the death penalty since you began practicing. Yet at the same time, we know that there are many states that are still deeply entrenched in their death penalty practices, and even when there are states such as Georgia that, during COVID had the contract that prevented executions, and it maybe seemed like there was going to be an end possibly in sight there, and then they, ended up executing Willie Pye last week. Some of these states just keep going, and what is kind of the next thing to be done in those states, like the next argument to be made, the next kind of case to be brought, or to kind of root out the death penalty's hold in those states?
Well, the next thing to be done in Georgia, of course, Willie Pye was intellectually disabled, and he was not found to be intellectually disabled because Georgia you have to prove it beyond reasonable doubt. It's almost impossible. Is there a reason to doubt whether somebody's intellectually disabled if they ever, have one score that raises any question about that? I saw where one of the Republican legislators is now offering legislation to change that. I don't know whether it'll pass or not, but that's important. But the most fundamental thing is the right to counsel. Virginia has carried out more executions than any other state in the history of the country. It carried out the very first execution in 1607. It's carried out more than any other state. They got these, and it used to be that if you were facing the death penalty in Virginia, you got some terrible court-appointed lawyer who was paid like $800 to represent you, and you got the death penalty, and it got upheld on appeal, and it got upheld on post-conviction, and they killed 113 people. And then in the early 2000s, they created 4 regional capital defender offices, and now you went from a place where everybody was represented by these incompetent, uncaring lawyers, to where no matter where you were in Virginia, you ended up with lawyers who knew what they were doing, specialized in death penalty cases, spent all their time on it, learning about it, doing it, and Virginia went for 10 years without a single person being sentenced to death, 2011 to 2021, and at the end of that time, they what the hell, why do we have the death penalty? And they repealed it. Here's Virginia, slave state, the leading executioner in the country, and they decided to repeal the death penalty, and it was all because of right to counsel, because they did without it for 10 years, and at that point, I think could say, we really don't need it. And I think what's really keeping the number of death sentences down today is that the days when you had the Houston-type places that just sentenced people to death in these perfunctory trials, they're not completely gone. There are still some places like that in Alabama and in Arkansas and in Texas, but they're fewer than there were before, and those are the only places that are still sentencing people to death anymore, unless it's some really extraordinary case. But even those, you take the Parkland case down in Florida, 17 people, the jury didn't give the death penalty, represented by the public defender there. So that's a great triumph for the right to counsel. Of course, then Florida changes its law, which again is one of our big problems here, is that criminal law is based on, sensational news reports and demagogic politicians. And so now Florida has a law that you can give the death penalty with only 8 jurors instead of 12, which nobody's ever had a law like that, and it wouldn't have a chance of being constitutional except for the Supreme Court. And it probably does have a shot. I don't know whether it'll be upheld or not, but we'll see.
So the only thing I would just add is I do think that, just back to Virginia, this really showcases the triumph and the continuing potential of these pragmatic arguments, like the asymmetry of resources between the state and the defendant, racism, regional differences, which are huge. All of these things are cited by the legislators in Virginia, and then the governor who finally signs the law abolishing the death penalty. These same, what I call pragmatic arguments that have been eroding support for capital punishment throughout these years, are the same arguments that have been showcased in many of these individual cases. In Washington State, where the Supreme Court there ended capital punishment, they pointed to the exact same kinds of arguments. Regional disparity, racial discrimination, the cost, and you start to see these arguments also in places like Utah. We'll see what happens in places like Utah. In Nevada, we see another push to abolish the death penalty there too, which would be a true shocker, I think, if they get there. So who knows? But the fact that Virginia has done it, I think, is the biggest surprise in a while.
Yeah, just to follow up on this question, because this is sort of where Steve's answer also was part of your epilogue of identifying, the federal, there's so much focus on the federal system. There haven't actually been that many executions of the federal system. It's about the states, and there's progress. You both are talking about progress on the states. And I just would invite, I think, on this question of some progress on the states is the way that the flip of some of the stories that you talk about, Steve, about elected judges have been problems and elected prosecutors have been a problem. There's a counter story still unfolding about the election of progressive criminal justice reform prosecutors. There's still a fight. Some of them are, it's not all going great for all of them, but there is still a movement where urban voters, as long as the districts are carved in a way, not like Cook County, but Philadelphia, there's no more, Lynn Abraham, wasn't it? Philadelphia had for many years, but now now that's been flipped. And so Boston is a bit of the story. Los Angeles, there are a number of these stories. So I just, I think this is consistent with your epilogue, but I would just invite some conversation about where you see the movement towards progressive prosecutors, criminal justice reform prosecutors, and how optimistic or not you are about how that will effectuate more of these changes. I'll let Steve.
Well, the other part of the Virginia story is that there were progressive prosecutors who were elected, and they came out against the death penalty, and they kept the Commonwealth Attorneys Association of Virginia from opposing the legislation. I think if they had opposed it, as they always had before, it would have probably not gotten passed. But they neutralized, they didn't support it. I mean, some of them did, quite a few of them actually, representing about 1/4 of the population of the state. So, that's not insignificant. I mean, that's very important. And so it's a combination of all these things that come into play.
Yeah.
Yeah.
Great. Other questions? One other thing I would add, I could ask questions for the rest of the night, but I won't subject you all to that. That would be cruel and unusual. But the, Eighth Amendment joke, sorry. But I wonder, well, first of all, when's the movie deal? Like, just mercy.
I'm
But,
waiting.
but I think, joke aside, I mean, when you Robert, when you talked about the public education component, right? This book is part of that. I wonder if this is also about the legal education component. So one audience is students, and so I wonder if you have this opportunity to communicate what this message is. And Steve, you've been doing this in addition to all the death penalty cases you've had as a litigator. All along the way, you were flying up to different law schools to also teach 40 students a semester. I wonder if you can reflect on that as a process of legal change. How much we have progressive prosecutors because they've gone to law schools where they had to actually see the nuts and bolts of or study these injustice problems, and how you use this moment to talk to an audience with many law students about their careers and how to live a good and just life. I'm gonna Robert first.
I hate speaking after Steve, so I'll go first. If I did my job, then I think just reading about the exploits of Steve Bright and the Southern Center will do much of that work of showing that there's a lot that can be done if you just stay at it and you're committed to the task. And even if you can't live the life that Steve Bright has and made the sacrifice he has, there are so many other people who have participated and helped along the way that you could do something like what they did. Cooperating attorneys, others who participated in this work. So if I've done that job well, then they'll get that message. The other message, though, that maybe requires a little more explicitness about is, and it was a little tricky to do in the book, was I wanted to also tell a story about changes in the law. And so even though you've got Steve Bright winning these important cases that are hard fought, the law itself is changing, particularly federal law, making it more difficult. So his first case, he gets a federal judge, he gets a hearing, they finally get the piece of evidence in. But over the years, as you alluded to this before, you had judge-made laws made by the Rehnquist court, making it procedurally more difficult to even get those kinds of things in evidence, to revisit criminal judgments. And then you get the AEDPA, which shuts the door even further. So that story was a little harder to tell, but I wanted to have that in this book so that people could think about what could be done next. And so insofar as there is work to be done, there's much that can be done at the state level. One example of that is maybe a source of inspiration is the Racial Justice Act enacted in California, probably the most far-reaching repudiation of McCleskey versus Kemp that any state could engage in. And they basically brushed aside all of this judge-made, state-based law that inhibited efforts to look at criminal judgments. So it's much easier now, if there's a claim of racial discrimination, to go back and try to reopen those cases. And they have reopened cases already. At the federal level, the AEDPA has to be revisited at some point. If there's any one thing to be done, it's that thing to be done. Because the stranglehold that act has had on the federal judiciary in making federal judges more indifferent and more willing to cite technicalities to avoid getting to the merits of questions is a travesty. So I wanted to make sure that people saw that as well. Questions?
Carol.
This is on the theme of humanizing the people, humanizing the defendants. And Steve talks very eloquently about Tony Amadeo and how he finally was released and became a productive member of society. Is that a theme that you find in more than just one case, and that you could use to try to reduce the attraction of the death penalty for people who reflexively think that somebody who did something horrible just has to be put away? And what can society do to increase the likelihood that people who are released do develop productive and become good law-abiding citizens in the community? Is there anything in their experience in going through the process of getting exonerated that helps? Does it mean, for example, that the fact that you, Steve Bright, stood with Tony Amadeo for so long meant that he felt that somebody cared and that somebody believed in him. I mean, I'd really be interested in your thoughts on these questions.
Mm-hmm.
Well, yeah, I think it's so important to humanize people, as you said, because I think the way that people see criminal people is this sort of undifferentiated mass of, terrible people who are, committing all sort of crimes and have no redeeming value whatsoever. And of course, life is much more complicated than that. And there certainly are some people who do some pretty terrible things and maybe some beyond the pale. But there are also a lot of people like Tony, who was only 18 years old. If he had been a month earlier, or a month or two younger, he wouldn't have even been eligible for the death penalty. But in terms of getting prepared, Tony was a self-starter. He was when he got away from all the bad influences that had led him to being in this case, in the case that he got sentenced to death, he really was. He went to college. Back in those days, you could go to college. He graduated from Mercer University, summa cum laude, going to college in prison. He became an expert woodworker and so forth. He made a lot of cabinets and desks and other things. He was known in the Georgia prison system that if you wanted some really nice woodwork, you got Tony Amadeo to do it. He took advantage of everything he could take advantage of. And so I think, that helped tremendously. It is, you raised the great point of what happens when people are released and you've been in prison for 38 years and you don't know how to use a cell phone. What happens when you come out? He had a lot of support from the whole Southern Center, but also he had a wonderful family. He had a tragic life. I mean, I would just tell one quick story. When he was 8 years old, they're going to spend Christmas with grandmother. And they're driving from Louisiana to Abilene, Texas, where grandmother lives. And as they're driving, they go over the hill in the middle of the night, and there's a pickup truck with no lights on. A head-on collision. Both parents are killed. One of his siblings was killed. Tony and his sister both thrown out of the car and terribly injured. So he overcame all that in life. But the sister that lived and some other relatives in Texas were very supportive. But not everybody has that. And so there's a real need, particularly with a lot of the people that come out that have serious mental illnesses, have intellectual disability. And unfortunately, for a lot of people, there's nobody there. And if we really care about these things, we really need to make sure there are people there because people can. There are an awful lot of people who are on death rows and in prison that could be making it in the community if there were only the opportunities for them to do so, both for them to be released and then to have the support. Jimmy Horton, I'll just mention real quickly because he's another good example. He was the head of the paint crew in the prisons, and he painted every prison in Georgia. I mean, he was there for a long time. When I was trying to get him paroled, I could go around to all these wardens and people, and Jimmy Horton had just done great work, and he painted not just the inside, he painted the outside. He had been out of the prisons, and so we had an awful lot of support when we went to the board, and not surprisingly, he got a job when he got out, and he was very, useful and productive. He had met a woman while he's in prison. A lot of people are very cynical about prison romances. I used to be, but not anymore because I've seen, these people get out. He's been out for years now, and he and Ms. Addie are still happily married. They're getting along well. Every time I'm in Georgia, we go out and have barbecue at the barbecue joint. It just depends. Everybody's an individual, but we have to meet people where they are, and if they don't have a family or if they have mental issues or drug issues or whatever, we got to deal with those. But there's a lot of human capital out there, and people have to understand the humanity of these people that we're condemning and imprisoning.
Thank you.
Great, yeah. We have two questions. Okay, no, please, yeah. Go ahead, great. What's your name?
Josh,
Great.
sorry, 1L. Professor Tsai, you started out at ACLU. Obviously, Professor Bright created the Southern Center. What would your message be to future lawyers, incoming lawyers, who are looking to kind of have the most impact on a system with systemic injustice? What are the levers that we can push on and activate? Is that working here at CPCS? Is that going to the Southern Center? What do you see kind of as the most impactful role that the next generation of lawyers can have?
Well, my answer to that very quickly is, I think the thing that many people find the law alienating. I think a lot of people who are lawyers are very alienated from it, wonder why they ever went to law school in the first place and what they're doing And my message is just that you can use the law to help people. And at the end of the day, what really matters, I had a friend died not too long ago, and somebody said in the end of the obituary, he spent his whole life helping people. I thought, at the end of the day, that's really what matters, isn't it? And legal services, I started out in legal services as a lawyer in the coal fields of Appalachia, representing poor people in every kind of civil matter under the sun, whether they're being evicted from their home because they can't pay the bank, or whether they're denied Social Security benefits, or whatever, my environmental issues, all kinds of things. I could have done that work for the rest of my life. It's great work, great clients. Every day I did something that helped somebody. And then I was a public defender for a number of years, and that was just the criminal side of representing poor people accused of crimes, and representing them from trying to get them out on bail all the way through sentencing and beyond. And I just recommend highly those careers to people, particularly as a place to start out. I started out there, and it was after I'd done the legal services work and the public defender work that then I went to Southern Center, and I started doing habeas work, which was sort of a combination of criminal and civil. And fortunately, I had a background in both. I'd done a lot of civil work, and I'd done a lot of criminal work, and so it worked out really well. I think, with me, I just, one thing led to another. And sometimes that's what you have to do in life, is just see where things take you. I was minding my own business, practicing law in Washington. Somebody called me and said, will you take a death penalty case in Georgia? And I'm like, why are you calling me? I'm not a death penalty lawyer. I'm a public defender. I'm not even an appellate lawyer. They said, we'll take anybody we can get. We got all these people under death sentence, and we don't have any lawyers for them. So, well, okay, we'll help this guy out. And so, as I said, one thing sort of led to another. You take these cases and you see what's happening, and you see the race discrimination, and you say, wow, if I get an opportunity to go down there and do this all the time and take a few friends of mine with me, we can make a difference on this. And it turned out we could,
So, Robert, you're seeing one of the challenges of biographers who write biographies of living people. Those of historians who write about dead people, I get the last word. The problem with writing about and having your living subject around is he might get the last word, but I'm actually going to give you, the privilege, even though Steve's here. Let me invite you to take the last word on this question of what you'd say to students.
Sure. No, I find it to be a good problem to have. It's been a pleasure to be able to write about Steve Bright's career, but I guess I have a very capacious view of public interest law. I'm pretty committed to careers in public interest. I think if you already know what you want to do, say if you really want to know that you want to dedicate your whole life to working on behalf of poor people, then you do exactly what Steve has described. Go to legal aid, go to Public Defender's Office, something like that. Lots of organizations who are concerned about poverty issues. But let's say you don't know, and that's probably more people. Then I do think there's value in learning about how different institutions and organizations work, because unless we actually do get rid of prosecutors, there will be prosecutors, and you need good people who understand how prosecution works, how those offices work, and you need to have someone to be able to deal with on the other side who's not a Joe Briley or somebody else that is in the book. And this is true whether it's at the local level or at DOJ or something like this. And you need to understand how judges think. So I think there's tremendous value in being able to try a bunch of different things as you try to figure out what to do.
Well, let's thank both of these inspiring figures here, so the heroes and leaders.
Thank you all.
Thank you so much to both of you for being here.